Indra, and it is my honor to serve you as the master of ceremony of today's public lecture. There's this book titled The Uninhabitable Earth. So in that book, David Wells writes, the question of how bad things will get is not actually a test of the science. It is a bet on the human activity. How much will we do to stall disaster and how quickly? The question, how much and how quickly, is ultimately a question about law, about what we mandate, what we enforce, and what we allow, and what we refuse to tolerate. It is a question about institutional design, about accountability, and about whose lives we choose to protect when the costs of inaction are distributed too unequally. Looking around this room, I see officials and lawmakers, legal scholars, academics, journalists, and advocates representing communities across Indonesia, from indigenous people to fisher folk, from women's rights organizations, and to environmental defenders. The diversity is not incidental. It is exactly the point. The answer to Walswell's question will not be written by any one institution, but it will be written by all of us together. This morning's program is as follows. We will open with the opening remarks from our Executive Director of ICEL, followed by the public lecture and question and answer sessions, and before we are going to close at noon. So before we begin, there's a quick note for all participants. So for those joining us in the room, the interpreter devices are available at the back. So please feel free to take one if you need one. So for those of you who are joining us via the Zoom meeting, you are able to use the interpretation feature available at the bottom of your screen. So let us begin. So to deliver the welcoming remarks on behalf of the Indonesian Center for Environmental Law, I would like to invite the Executive Director of ICEL, Ibu Lasma Natalia SHMH. So to Ibu Lasma, the floor is yours. Please give a round of applause, everyone.
Selamat pagi, salam sejahtera untuk kita semua. Pertama-tama yang saya hormati, terima kasih kepada Prof.Dr. Michael Faure yang sudah menyempatkan waktu. Thanks for your coming and you have time to discuss with us today. Dan terima kasih juga kepada rekan-rekan masyarakat sipil, akademisi, teman-teman mahasiswa yang hari ini sudah hadir sebagai peserta. Sebenarnya pendaftaran cukup tinggi antusiasnya sehingga kami batasi sebenarnya saat ini ada yang offline dan online. Sebenarnya yang offline masih terkena macet ya, jadi masih ada beberapa kursi yang tersedia, tapi beberapa sebagian akhirnya kami arahkan untuk mengikuti diskusi hari ini secara online. Hari ini sebenarnya kita melihat bahwa diskursus tentang krisis iklim itu sudah semakin tinggi dibicarakan di Indonesia karena krisis iklim bukan sesuatu yang jauh, tapi dampaknya itu sungguh sudah dirasakan langsung terhadap masyarakat. Misalnya kita lihat beberapa tahun terakhir sudah terjadi banjir, cuaca ekstrim yang berulang di beberapa wilayah yang bahkan sebelumnya belum pernah terjadi. Bahkan kalau kita lihat juga di wilayah pesisir dan pulau-pulau kecil, kenaikan muka air laut mulai mengancam ruang hidup masyarakat. Lalu itu berdampak juga terhadap nelayan yang mengalami penurunan hasil tangkapan dan karena perubahan suhu laut, dan juga krisis iklim juga memperburuk sebenarnya kebakaran hutan dan lahan, dan dampaknya tidak hanya secara ekosistem tapi juga menimbulkan krisis kesehatan akibat polusi udara dan kabut asap yang berulang setiap tahunnya. Nah, namun yang paling penting, kelompok yang paling terdampak dari situasi krisis iklim di Indonesia ini adalah mereka yang memiliki kapasitas paling kecil untuk bertahan dan beradaptasi, yaitu masyarakat adat, perempuan, nelayan kecil, petani, masyarakat pesisir, penyandang disabilitas, serta kelompok miskin di perkotaan dan pedesaan. Sehingga krisis iklim adalah keterkaitan erat antara lingkungan dan keadilan itu sendiri. Nah, ketika kita bicara soal keadilan iklim, pertanyaannya, apakah hukum kita benar-benar sudah melindungi mereka yang paling terdampak? Kalau kita mau berefleksi terhadap sistem hukum di Indonesia saat ini, tentu kita masih menghadapi banyak tantangan untuk menjawab pertanyaan tersebut. Dan jika kita melihat juga bagaimana regulasi perubahan iklim di Indonesia saat ini masih tersebar di berbagai sektor dan belum memiliki satu kerangka hukum yang benar-benar utuh. Banyak kebijakan yang masih fokus pada target administratif, sementara aspek perlindungan masyarakat, pemulihan lingkungan, akses terhadap keadilan belum menjadi perhatian utama. Di saat yang sama, kalau kita lihat Indonesia saat ini berada dalam fase besar dalam transisi ekonomi dan energi. Kita kadang bicara soal energi bersih, hilirisasi mineral kritis, pembangunan rendah karbon, tapi sebenarnya situasi-situasi tersebut juga menghadirkan konflik-konflik baru di lapangan seperti konflik lahan, pencemaran, tekanan terhadap wilayah adat, hingga kriminalisasi warga yang mempertahankan ruang hidupnya. Untuk itu, kita membutuhkan desain hukum yang kuat. Salah satunya bagaimana mengatur terkait penegakan hukum dalam konteks krisis iklim, sehingga tidak hanya dipahami soal memberi sanksi setelah kerusakan terjadi, tapi penegakan hukum harus mampu melindungi, memulihkan, bahkan mencegah. Dan yang paling penting memastikan bahwa kelompok paling rentan dan yang paling rentan tidak terus-menerus menjadi pihak yang dikorbankan. Hari ini diskusi kita menjadi penting, bagaimana kita berdiskusi ya, sebaiknya penegakan hukum dirancang seperti apa sehingga itu terwujud dalam kerangka keadilan iklim. Bagaimana hukum bekerja bukan hanya sebagai alat kontrol, tapi juga sebagai alat untuk menghadirkan keadilan sosial dan ekologis. Untuk itu, hari ini pagi ini sudah hadir bersama kita Prof.Dr. Faure. Beliau memiliki pengalaman dan kontribusi yang besar dalam pengembangan hukum lingkungan nasional dan internasional, termasuk bagaimana merancang instrumen penegakan hukum untuk menghadapi risiko lingkungan dan perubahan iklim. Saya rasa perspektif ini jadi penting bagi Indonesia, terutama saat ini kan kita sedang mendorong penguatan kerangka hukum keadilan iklim dan mulai mendiskusikan kebutuhan akan pendekatan hukum yang lebih komprehensif dan lebih berpihak kepada masyarakat terdampak. Harapannya forum ini menjadi ruang terbuka untuk kita bertukar gagasan dan juga merefleksikan bagaimana sebaiknya mendorong regulasi dan kebijakan hukum yang adil dalam menghadapi krisis iklim di Indonesia. Terima kasih dan selamat berdiskusi untuk kita semua.
Thank you so much, Ibu Lasma, for your meaningful speech. Can we please give another round of applause for Ibu Lasma? Okay, Bapak dan Ibu yang saya hormati, distinguished guest, to address the question of how law enforcement should be designed within a climate justice framework, we are deeply honored to have with us one of the world's foremost scholars at the intersection of law, economics, and environmental policy. Our speaker today studied law at the University of Antwerp, criminology at the University of Ghent, and obtained his Master of Laws from the University of Chicago Law School in 1984. He is professor of comparative and international environmental law at Maastricht University, where since 1991 he has served as the academic director of METRO, the Maastricht European Institute for Transnational Legal Research, and he's also a professor of comparative private law and economics at Erasmus University, academic director of the Youth Commune Research School, and a practicing attorney at the Antwerp Bar since 1982. And just days ago, on the 19th of May, he was inaugurated as adjunct professor of the Faculty of Law, Universitas Indonesia, making his relationship with this country now formally more institutional. So ladies and gentlemen, Bapak dan Ibu sekalian, please join me in warmly welcoming Professor Dr. Michael Faure. And to facilitate this discussion, I would like to invite our moderator, Marsa Albar, to take the floor. Thank you.
Test, test, test. Yeah? Okay. Shall I start all over again? Ladies and gentlemen, also wanted to thank all of you pardon, who are following us online. And I have been asked to talk a little bit about how to design a law enforcement framework within a climate justice framework. And as I have sketched there a little bit the order of what I will be discussing, first I want to sketch a little bit what is the goal of the talk here. You know, there is some experience with climate law in different countries, and also with the enforcement framework that we have built on to make sure that there is also compliance with that framework. And I want to talk a little bit about that, but I don't only want to talk about the policy that we have put in place, I also want to talk a little bit about the theory. If we were to design an effective enforcement system for climate law, how should we do it? What type of instruments would we use? And, you know, many countries have now experience with climate law, so I think it's also important to look around and ask the question, what has really worked? So that's a little bit what I want to do. Now, one of the first points that I want to make, I always like it very much. In Indonesia, I noticed in law schools, at the policy and in politics, the most popular word that I have come across in the past weeks every time is justice. Now, apparently Indonesia is in a great need for justice. And you could say, who can be against that? Environmental justice, climate justice, those are, of course, wonderful goals to strive for. What I find sometimes a little bit a problem is that many talk about justice, but I hear very little definition of what we exactly mean with justice, also when we talk about climate justice. Now, you know, when we go back to our friend Aristotle, who invented this whole concept of justice, you might remember that Aristotle made a distinction between distributive justice and corrective justice. Now, both may be relevant in the climate change context. You could say distributive justice, what this is about protecting the vulnerable, protecting the poor, making sure that they also get protected and do not lose in the climate struggle. And then you could say, for example, protecting least developed countries and small island states against consequences of climate change is an important climate justice task, distributive justice. If you then look at corrective justice talks much more about making those responsible for harm that they have caused also pay for the consequences of that harm. So with corrective justice, you look much more also at the ones who were at the origin, and in this case, of course, of greenhouse gas emissions. Now, so far, so good. That's what we know for more than 2,000 years. But now, of course, how would you apply that concretely? And then, of course, it gets sometimes complicated. You know, it's easy if you say it's clear who the injurer is, who the victim is. For example, if you compare the United States with an island like Tuvalu, say pretty clear. You hear of a situation where, and from a corrective and for a distributive justice perspective, you would say it's not too difficult to argue that the one who should pay here is the US, and for corrective and for distributive reasons, and the one who should receive is Tuvalu, and because they are the victim, distributive, and because they never caught anything, corrective justice, you see. Also, if you would compare the role of Shell versus the role of a few small farmers, maybe on an island in Indonesia, then it's all relatively easy. It gets more complicated if you look at these issues in an intertemporal perspective. Then you're going to say, okay, are we going to put now all the obligations on the current emitters? You could say, yeah, that makes a lot of sense from a corrective justice perspective. But then if you think a little bit more and say, wait a moment, the current emitters, then we talk strongly about China, about Indonesia, about many countries also in the south, who are not liable necessarily for the historic emissions. And then the question, of course, means to what does that lean if you also take these historical emissions into account? You know, again, this whole justice framework is nice if injurers and victims are in the same country. Again, my example of the US and Tuvalu. But now take, for example, the example of India. Take the example of Brazil or of Indonesia. What does it mean, climate justice? Well, those countries are to some extent all victims. Indonesia as well, sea level rise. And you see indeed that from a distributive justice perspective, Indonesia should therefore be the receiver, for example, in discussions on loss and damage. On the other hand, Indonesia is undoubtedly also an injurer. Massive deforestation contributing to greenhouse gas emissions and also CO2 emissions and other greenhouse gases, which are rather impressive. And then from a corrective justice perspective, it should also contribute. So what is, ladies and gentlemen, a little bit my conclusion, that I say, look, talking about climate justice, I see it a little bit as the foundation. It is good to build discussions on enforcement on climate justice, but what I wrote there, I find it important to go beyond climate justice, because only talking about climate justice will not save the world. So we have to take that as a starting point, and then we have to say, okay, if we now interpret what it concretely means as far as regulation and as far as enforcement is concerned, let us then go a bit more in detail. And that's what I would like to do with you now. I'm just asking the interpreter, I have the tendency of getting enthusiastic and talking too fast. Am I still doing okay? Okay. If you get nervous from me, just say and I will slow down, okay? Good. Second point, in the terms of reference, one of the questions that was asked to me, is a statute, is a regulatory framework needed? And I honestly, when I saw the terms of reference, was a bit surprised, almost thinking, how can you ask that? Of course we need a regulatory framework. Of course we need legislation. It sounds logic. Why? Well, it's pretty simple. A regulatory framework is needed before you can have any talk about enforcement. What are you otherwise going to enforce if there is no regulatory framework? The regulatory framework should provide the institutional mechanisms that tell who has competences to do what. It has to specify the goals of climate change policy in a country, and it also has to specify what are the actions that need to be undertaken for mitigation, adaptation, loss and damage, and specifically how the energy transition necessary for climate change, how that will take place. In other words, all the targets and the instruments need to be specified in legislation. And I personally think that for most countries, the existing legal instruments are not sufficient. It's not that you can say, we're now going to do climate policy with our civil code or with our penal code or with administrative law acts. That's not going to work. And pretty simple, without statute, we have no law enforcement. So if I want to talk about law enforcement, I logically first need a statute. Now, we're lucky because many countries now have climate laws. And if you go on internet, you can even find whole overviews with comparisons. Well, they will tell you what the common denominators are, in other words, what will you find back in all types of climate law. So if you are a country that does not have a climate law yet, hypothetically, it's not so difficult. You don't have to invent the wheel again. Just go on the internet, you'll find nice overviews on what's there, and you can find inspiration and think what fits best with my country. What I want to do then next is say, okay, we assume for a moment that we have a statute, that we have law, and then we focus on enforcement. And of course, you know, in theory, I come at the third point there, in theory, we have a variety of different instruments that we can use for enforcement. And I think it is important to provide you a bit of this theory, because you will notice that what we see in practice in many countries does not always follow the theory. What is the theory telling us? Well, pretty simple. We have three models: private enforcement, we have public enforcement, administrative law, public enforcement, criminal law. Those are roughly the three tastes that are out there. Now let me, with you, briefly go over these three options and then apply that to climate law and ask the question, which of those seems the most logic to use? First, private enforcement liability rules. When we talk about private enforcement, you could say, Michael, there is also property rights, there is also contract law, sure. But you know, contracting between victims and insurers in climate change is not very likely. And you could say a property rights approach may work with marketable permits. Those I will discuss in a minute. That's a different story. But classic liability law, whereby an insurer, here emitter of greenhouse gases, would be made liable for damage, in this case, harm caused by climate change. Would it now be logic that we use liability rules as the primary instrument to enforce climate change legislation? Ladies and gentlemen, my answer would be no, not as primary instrument, and for a variety of reasons. First, of course, we have the problem of access to justice. You know, it's very simple. If you are an individual victim having to file a lawsuit, that's a very expensive exercise. You'll have to pay all the expensive American law firms in Jakarta that charge $500 an hour in fees. Why would you do that? And the reason I ask why would you do that is that there is one particular feature of climate harm. Climate harm is differently than most or different cases of environmental harm, not individual harm. There is often what we call a collective action problem. What does it mean? It means that the damage is widespread over a large community, maybe a whole country, a whole region, the world. What does it mean? It means that as a result of that, an individual can suffer relatively small harm. And that individual will sometimes have rational disinterest and will not bring a lawsuit, also because all the others might potentially benefit from that. So what you see is that de facto for individual victims to bring lawsuits for climate-related harm, that is not easy to say the least. And then, ladies and gentlemen, I'm not even talking about problems like latency. You know, latency is the fact that there is often a long time lapse between an emission and the damage. And of course, when the time lapse is very long, like with climate change, emissions could have started in the 19th century, the damage is occurring today, then logically, it may be much more difficult to find the wrongdoer and to identify who exactly caused the harm. And of course, typical with climate change, we have not one actor, we have millions of actors, we have multi-party causation, multiple injurers, making it even more complicated to apply classic tort law. Now that is why you should not be surprised if you look, for example, at an European directive of the 21st of April 2004 on environmental liability. When they discuss the scope, they say explicitly in Article 4.5, this directive shall only apply to environmental damage or to an imminent threat of such damage caused by pollution of a diffuse character, where it is possible to establish a causal link between the damage and the activities of individual operators. So they explicitly require causation for the directive to apply in case of diffuse harm, and also in the recitals recital 13, they say the same. The damage should be concrete and quantifiable, and a causal link should be established between the damage and the identified polluter. Liability is therefore not a suitable instrument for dealing with pollution of a widespread, diffuse character, where it is impossible to link the negative environmental effects with acts or failure to act of a certain individual actor. So you see here, they don't mention the word climate change, but you can understand if you read this carefully that they're basically saying applying private enforcement liability rules to climate change, least what you can say, difficult. And then I have not even mentioned one of the most important aspects. If you would be claiming compensation, you could of course say that the harm caused by climate change is of such a nature that it may be a lot larger than individual wealth of a particular perpetrator. And then we could have an insolvency problem. Now, an additional issue is that theoretically we say, you know, private law, private enforcement works very well in cases where you have a probability to be caught, what we sometimes call probability of detection of 100%. In other words, you're sure that the perpetrator gets caught. Why is that important? Because private law forces an injurer to put the victim back, in theory, in the position he was before the accident. In other words, what is the remedy? The remedy is compensating the harm done, but not more than that. Now, what we say is that works very well if all injurers get caught. So if detection rate is 100%. However, with climate change, we know quite well, detection rates are never 100%, may even be a lot lower. And then if you want to deter, if, in other words, you want to use liability rules as an enforcement mechanism, as a deterrence mechanism, then of course the issue is you would need a remedy that is a lot larger than the harm that has been caused. And classic tort law does not allow for that. What does that mean? It means that the way liability rules, private enforcement is structured is not ideal to make this the primary instrument. However, I say immediately, there are many ways of improving the working of private enforcement. And we have seen that in many legal systems. For example, the widespread nature of the damage you can solve with environmental public interest litigation. We see in many countries. China is an example that is very strong in that. Europe also many examples. You can solve it also by granting generous standing to non-governmental organizations. And in other words, to look for mechanisms, remedies, to solve the collective action problem. Same story for uncertainty over causation. There are also solutions. For example, working with a proportional liability rule, whereby you would allow a claim against an emitter in relation to the amount that that emitter contributed to global greenhouse gases. What exactly was the case, what the Peruvian farmer, Mr. Luya, was doing in his case against RWE. So there are solutions, but still not the primary instrument. I don't say never use it, but not the primary instrument. Primary instrument is regulation with, therefore, public enforcement. When we say public enforcement, the first instrument we look at is, of course, administrative law. The nice thing is, administrative law can solve our problem of the low detection rate. Why? It does not have the problem that liability rules have, that your remedy, compensation, is limited to the harm caused. No. With administrative fines, in principle, you can impose an amount of a fine which is much higher than the harm caused to deal with this low detection rate. So yes, this may work. There is, however, also a problem with administrative fines in the following case. Suppose now for a moment that the benefit that you would obtain from emitting greenhouse gases would be very high, very realistic, if you were a large energy producer. If the probability that you get caught is very low, also realistic. Think about corruption issues, if you bribe officers. What would that mean? It would mean that the fine that would be imposed should now be much higher to deal with the high benefit and the low probability of detection. But then we get a problem. The problem being, it may be that the fine that would have to be imposed is so large that it is larger than the assets, than the wealth of the operator. You see, this is a realistic issue in climate change law. We often think about very large emitters, but there are also small and medium-sized enterprises that can have large greenhouse gas emissions. And sometimes they have huge benefits from that, low probability of detection, and we would need a very high fine that they simply cannot pay. What does that mean? That means then we come to the limits of administrative law, and we may need criminal sanctions, non-monetary sanctions, like, for example, imprisonment in this particular case. And of course, we don't want the criminal sanction, the prison sanction, to be imposed by an administrative authority, because we also want all the guarantees of criminal procedure, that we only punish the guilty ones and not the innocent ones. Now, if you're still with me, and you take that story a little bit together, what is the summary? First, we need regulation, and mark you, when I say regulation, that can be market-based instruments like emission trading or taxes, plus administrative sanctions. But if the benefits to the operator are very high, we may need criminal sanctions as well. And I have not forgotten private enforcement. I say private enforcement in climate law can play an important role as a complementary, as a supplementary instrument. In other words, theory would advocate for what we call a smart mix between administrative, criminal, and private enforcement. As such, sometimes there is a mistake. People see market-based instrument as a separate enforcement category. Of course, they are not. Also, market-based instruments need to be enforced through all of these mechanisms that I talked about here. Now, ladies and gentlemen, that is, as an academic should do, the theory. And now, let's go to the next point. What do we see in reality? What do we see in practice? Let's go there. Well, in many of the countries that I am aware of, China, some states in the US, Australia, EU, we see a large use of market-based instruments as, important for you, the main instrument of climate policy. That can either be an emission trading scheme, or in some countries it can be taxation. The bottom line of those mechanisms is carbon pricing. We allocate the price to carbon in order to provide incentives to operators to reduce greenhouse gas emissions mitigation. That is the bottom line. We see a little bit of command and control mechanisms as well. For example, there should be permits for CO2 emissions. We see in the energy transition that there is some pure regulation. There is deforestation regulation, zoning, and so that is also more classic regulation, not necessarily market-based. But now there is something important. Some people make the mistake of thinking when you say market-based, it means you don't need government. Whereas the opposite is true. Market-based instruments only work on the basis of detailed government regulation. What should the government do? First of all, the government, for example, in an emission trading system, should determine the cap. The government should organize the trading. The government also regulates prices. It may be that suddenly prices are too high, too low. The government intervenes in the market to create efficiency. Same story with taxation. Also there, it is the government that will organize the system. So it is market-based in the sense that the government tells you what the price is, for example, in a taxation system, or what the maximum quantity is of emissions. That is regulated, and the government does not tell you how to reduce greenhouse gases. That is up to you. That is the market-based element. But the whole organization, the whole framework, needs strong institutions. Quite important for you to remember that. Plus, crucial, market-based mechanisms only work with strong enforcement by government to guarantee compliance. How is this done in most systems? I would say in a peculiar way, to put it politely. We rely in emission trading schemes, China, US, Europe, we rely on self-reporting of greenhouse gases. An operator has a permit, and the operator will then report in the past year how many greenhouse gases it has been emitting. Now it becomes interesting. It makes a report with these emissions. Who is going to control that? The government? No. There is control by private verifiers. These are private companies, certified companies, and so the certifier is paid by the operator, and the operator gives his report to the certification organization, and the verifier will check whether in principle this all looks okay. This is, ladies and gentlemen, for 90% a paper operation. They do not necessarily go there to see what the real emissions were, but they see whether the report looks okay. That's what they do. And then they send it to the government. And again, what is the government doing? The government will control whether the reports are okay. The government does not do a site visit, in principle. Now, if things are wrong, you could already say, Michael, how can things go wrong in such a system? It looks pretty good for the company. If things go wrong, only administrative fines apply. For example, in Europe, it was 100 euro per ton of a fine. Meanwhile, it's higher because there has been an adaptation to inflation. Now, what is important to remember, you have two types of violations. Either you could underreport, so you report, for example, you had 10,000 tons of CO2 emissions, whereas you had in fact 20,000, that's an underreporting. Or what you could do is not surrendering. Most violations are the latter. What does it mean? It means that, for example, you had 10,000 tons in the last year, and what is then the idea? You should buy allowances on the market for these 10,000 tons. That's how the system works. And those should be surrendered to the government. That is how an emission trading scheme works. And so what could also go wrong, that for your 10,000 tons, you do not have the corresponding allowances. That is also a sin. That is a violation that could give rise to application of a fine. Quite important, in most climate laws that I know, I say immediately I don't know all of them, So maybe someone says, Michael, you're wrong. There is an exception in New Zealand or so, I don't know. But in most laws that I'm aware of, there is no criminal law sanction in the climate law. You could say, Michael, wait a moment. Suppose that someone is really doing something nasty, is emitting much more than was allowed, and moreover, lies about this in the report. In the report they write, I have emitted 10,000 and they have emitted 20,000. Well, then you could say, Michael, that's a fraud. That's correct. And so in principle, you know, we are not allowed to commit fraud on paper. That is prohibited in criminal codes, in penal codes, in most countries. So in theory, yes, if you have a fraudulent reporting, that could be subject to criminal provisions, classic criminal provisions, not geared specifically towards climate law. Correct. I come to my point 5, and then I say, okay, if I evaluate all of this, I think that I slowly have to change my story. If I evaluate all of this, and then I look at this, and I say, I think I accidentally skipped one. Yes, here I am. Here is my evaluation. If I look, and you know, ladies and gentlemen, I would compare my theoretical story from 10 minutes ago with what we have seen in practice. What is then striking? Striking number 1, you remember that I was telling you an efficient, smart mix of instruments for climate law would also contain criminal law. Most legal systems in the climate law do not have criminal law. That's one, what I find striking feature, not corresponding with the theory. There is something typical. If you look at government reports and what industry tells us, they all say compliance is very, very high. Can be reasons for, talk about it in a minute. But what do we also see? We sometimes occasionally see cases coming out where there is non-compliance. And then striking, usually the violations are pretty spectacular. Like there was one recently in China where there was a company forgetting to surrender 100,000 tons of allowances. Now that's a lot. So that can simply mean that if you don't surrender that the whole cap of a country would be breached. Because the consequences, if one company really violates, that of course has consequences for the total volume of emissions in a country. Of course, when you say the compliance would be very high, a cynical person could ask, but is the cap in fact effective? Does that not mean that our cap is much too high, making it too easy to comply? You know, there is something which I find striking. My friends from the NGOs in countries that I know do not focus a lot, in fact not at all, on compliance with emission trading schemes. They do a lot of climate change litigation, and I can tell you that with us, let's say the academics working in climate change law, we are sometimes a bit surprised. Because we say, you know, there is a lot of regulation, there is ETS, there is carbon pricing. If that regulation would be complied with perfectly, already there would be great reductions of emissions. Now, there is a variety of reasons why there is a lacking interest, I put it this way, of NGOs in compliance and enforcement. One of them, it's very complicated. It's not easy. Second, NGOs are also dependent on support from donors. And enforcement is not a very attractive issue to talk about. Climate change litigation gets you on the newspapers. That's good for donors. That's good for attracting funding. So that's one of the reasons why you sometimes have the impression, strategically, this is not something that they are focusing on. And also, it is sometimes very complicated. It's not so easy to engage in this type of research. If you want later, I can tell you, I've at some moment been contacted by Client Earth. They asked me to do a research where we would compare the enforcement and sanctions on economic laws compared to environmental laws. Because they had the point, and I think they might be right, that sanctions for environmental law are much more lenient and lower than for violations of economic law. But then we started thinking about how to structure this, and then it became so complicated. If you want to go beyond the law, and you want to know what are the sanctions applied in practice, and you want to know what is the probability of detection, how many officers are there for controlling compliance, that I have to tell you honestly, together with my friends from the Earth, we said together it's impossible to do this in an academically decent way, and so we had to give up the whole project. If we look at this, and so you see a little bit what are the limitations and what is the evaluation. What are some ideas for what could change? Well, one of the obvious questions is, of course, would we need criminal law also to enforce climate law? A good friend of mine, former Advocate General at the Hoge Raad in the Netherlands, Jaap Spier, wrote the Oslo Legal Principles on Obligations of States for Combating Climate Change. Jaap Spier gave in Maastricht 15 years ago a lecture on climate change, and I remember he said at that moment, climate change will cause more victims, it's his words and not mine, than Hitler, Mao, and Stalin together. That's what he said. People reacted like you in the room. There was a shock that went to the room, and they were all saying, I mean, this guy is crazy. You know, now, if you look at the data, and if you look, I'm not sure that Jaap was that crazy with what he was saying. If you look at the numbers, and if you see what may be happening as far as catastrophes and disasters coming in our direction. Therefore, if you talk to Jaap Spier, his answer is clear. He says the companies that are emitting now large-scale greenhouse gases, they commit criminal behavior, and they should be prosecuted. He said we had no doubt that the names I mentioned earlier had to be prosecuted for horrible genocides and so. Now these people, they do intentionally and willingly, and they know what's going on, they do the same. That's his story. You know, that is a nice story, but it doesn't mean that legally you have a criminal claim yet, you know. There is a guy in the Netherlands, Sjoerd Lopik, defended in September in Leiden, University of Leiden, a PhD thesis on applying criminal law to climate change. He looked at the possibilities of current law in the Netherlands, and his conclusions were, I'm not going to say depressing, but he was basically saying to apply current environmental law in a meaningful way to climate change is extremely difficult. Because he said, yeah, most of climate law is administrative law. So you look at regulations, and yes, you might then look if there is a possibility of they violate regulations. Maybe if there is intent, then you could apply fraud. But the whole difficulty with fraud is you need to prove intent. So you have to show that there was an intentional violation, which is not that easy at all. Now, if you would like to expand criminal law to climate change, how to do it? Well, there's a couple of ways that you can walk. One is that you look at administrative violations. You know, I think the alternative of saying we make someone liable for causing climate change, I tell you honestly, that's a no-go. For the simple reason, the causal uncertainty is so high that this is something that will never fly in a court, I think. But of course, why not say you have a carbon pricing system, ETS or taxation, and you link criminal sanctions to that when there is a particular threshold of high emissions. This is something you could think about. that can certainly be criminalized. But what you need to realize, in the criminal law, the crucial issue is the legality principle. So you need to describe very precisely and very clearly what the conditions for criminal liability are, so that the potential offender knows before the act was committed what the violation might be. If you want to go for climate change itself, is there some potential? Well, in Europe, we have a couple of exciting developments in the domain of criminal law. There is a directive of the 11th of April 2024, Environmental Crime Directive, and this directive introduced the criminalization of what they call ecocide. There is a qualified crime of ecocide. And it says ecocide is the destruction of or widespread and substantial damage, which is either irreversible or long-lasting to an ecosystem of considerable size or environmental value or a habitat within a protected site. Now, I think that some could try to examine whether serious climate change indeed considers such a destruction or of a widespread and substantial damage which is long-lasting or irreversible. Maybe you could argue that, and then you could bring it under the ecocide provision, if that would be translated. You know, when this provision was introduced in the Environmental Crime Directive, and we were discussing about this, I warned at some moment the Green Party who took this initiative. I said, there is one little detail that you should be careful with. Do you realize that you can commit ecocide and do all these horrible things if you do that covered by a permit? There is no criminal liability. They looked at me, Michael, that cannot be true. What do you mean? I said, well, I'll explain to you. There is only criminal liability in case of unlawfulness. What is unlawfulness? Violating conditions of regulation or a permit. So if you violate conditions of a permit, there is unlawfulness. However, if you follow the conditions of a permit, so the permit grants you the right to emit greenhouse gases in large quantities, there is never unlawfulness. And if there is no unlawfulness, you can commit ecocide, long, everlasting, you've heard it, but there is no criminal liability. And my friends, the Greens in the Parliament, Michael, that cannot be the case. I said, okay. I said, but then we're going to change it. If you don't like that, and I don't like that, they didn't like it, then we need autonomous environmental crimes. What are those? An autonomous environmental crime is where you can have criminal liability even if you comply with the conditions of a permit. And I argue that this is what we now have in the Environmental Crime Directive. Why? There is a magical Article 3b that says, such conduct shall be unlawful even when it is carried out under an authorization issued by a competent authority of a member state, if such an authorization was obtained fraudulently or by corruption, extortion, or coercion. That I understand, not very spectacular, but now listen carefully. Or if such authorization, it comes, my sentence, is in manifest breach of relevant substantive legal requirements. What does it mean? You follow the conditions of a permit, but you breach relevant substantive legal requirements, then criminal liability can apply. You're going to ask me, Michael, what are relevant substantive legal requirements? Very simple, human rights. What are we talking about here? The right to life, the right to family life. There is consistent human rights case law saying that cases of heavy environmental pollution can cause a human rights violation. So you see, this, according to me, opens the route towards an autonomous environmental crime of ecocide, but also more generally. And so that, of course, opens also possibilities for climate change criminal liability. If you have the right provisions, then it signals also to an operator, ho, if you comply with the permit to emit greenhouse gases, but you also breach relevant substantive legal requirements, then criminal liability still applies. And I personally think it is not difficult to argue that very heavy substantial greenhouse gas emissions constitute a human rights violation. Look at the case law of the court in Strasbourg considering, for example, Klimazinnen urinen. Then we know, one-on-one, that that is a relevant substantive legal requirement. So you see, there are openings. It's complicated, but not impossible. And there have been important changes. How that will be interpreted in Europe, we still have to see. Should be interpreted by now, May of this year in the member states, should be implemented, transposed, wait and see. You know what is the magic of criminal liability? That of course we can allocate criminal liability and to the corporation, but also to directors and officers. And there has been a Dutch scholar defending a PhD thesis, Tim Bleker, who argued that there should be individual criminal liability of directors and officers who willingly contributed to serious greenhouse gas emissions that contributed substantially to climate change. Now, if you take that seriously, just name the companies with large greenhouse gas emissions and think about criminal actions not only against the corporations, but also against individuals. I guarantee you that that will lead to a small shock in the boardroom. That's something they don't like. I come to my next point, where it says there, CCL. Because I told you, my ideal model, regulation with administrative fines, plus, if it were up to me, criminal law. But I also told you, private enforcement, climate change liability, let's not forget it. I want to say climate change liability remains important. Why? Very often, the standards set, for example, in an emission trading scheme, are simply too low. That was the argument of the lawyer of the Urgenda Foundation, Roger Cox. He said, you can perfectly comply with the emission trading scheme, but that does not avoid dangerous climate change from occurring. And you, Dutch state, are committing a tort. You're acting unlawfully, negligently. And that, up till the Supreme Court, the Hoge Raad, was accepted, that argument, as a result of which the Dutch state was convicted to take further going measures. I think that against weak standards and weak enforcement, climate change litigation is an extremely important instrument because it has the advantage that it can push the government to go further, and it can, moreover, also lead to further accountability of operators. For example, this whole Shell case, Milieudefensie against Shell, that is pleaded before the Hoge Raad exactly this month in the Netherlands after appeal. That was a case that has led to spectacular consequences, not only for Shell, but the whole community of the oil and gas producers were very well aware of that, and people claim that it led to substantial reductions of greenhouse gas emissions, also of other corporations that feared that they would be confronted with similar lawsuits. In other words, this climate change litigation can have a ripple effect, we call it ripples on, beyond just the individual case. My next point is I was asked in the terms of reference to talk also about restoration. And I have to tell you honestly that when I saw restoration in relation to climate change, I was surprised. And let me tell you why. When I think of climate change, I often think of dramatic consequences. I look at the Lake Chad in Africa that has been reduced in a few years by 70%. How are you going to restore that? I think about small island states like Tuvalu, that as a result of increasing seawater levels, risk of completely disappearing. How do you do restoration there? You know, I can continue. Only, I think, if you talk, for example, about a bushfire, that you would say, okay, a bushfire has been caused, or there has been deforestation, that in those cases you say, sure, restoration could be a reforestation, or maybe an obligation to restore the harm done as a result of the bushfire. But to be very clear, that is much more limited than the real climate harm that we are talking about. And so, when I think of restoration, I rather think of compensation. In other words, when restoration is impossible, and I think unfortunately, most of the climate harm cannot be restored, then the only thing that we can talk about is loss and damage. And then, of course, the question arises, how should we organize that? Well, there is basically three models. And just going to sketch you the main principles, because those are issues on which we could talk for the whole morning. The first preferred model is, of course, that loss and damage, restoration, would be paid by the liable polluter. Now, why? This is a clear link with the corrective justice principle. It is the polluter who is liable, should therefore also be responsible for the compensation. That is the advantage, that it not only provides compensation, but also provides incentives for prevention if you allocate the costs correctly to the polluter. But, you know, this works if you have simple cases, simple pollution cases, with an identifiable polluter. In climate change, where you talk about multiple actors, it's extremely difficult unless you take the exceptional case like Luya, but there again, Luya was claiming 0.074% of his damage from RWE. And then you can also ask, okay, suppose that the case would have succeeded and he got that compensation, who is going to pay the rest of the 99, etc. % of the damage? So, not that easy. Of course, other possibility, when you talk about loss and damage, realistically, what are we often talking about? About climate change disasters, hurricanes, flooding. And what is the issue there? In many legal systems for disasters today, we do have mechanisms. Insurance. Now, the advantage of insurance is that it compensates irrespective of the cause of the harm. In other words, you don't have to prove that this hurricane or this flooding or this heavy rain was caused by climate change. Why? This is a first-party insurance that you take as a potential victim for your future losses, and the insurance company looks at the loss, whether the loss occurred or not. Is not going to ask, was the cause climate change or not? So yes, first-party insurance has also the great advantage that it provides incentives for mitigation of losses, because it will force you as a potential victim, for example, to take measures aimed at a mitigation of the damages. what is a big issue here, when you talk here about reparation, about loss and damage, in a first-party insurance framework, who pays the premium in this model? The victim. So you talk about the victim pays model. And that is something that sometimes makes people understandably nervous. I understand that nervosity. And especially when you look at developing countries, global south, you can ask questions about capacity. Can they pay the insurance premium? But then sometimes I think, let us think out of the box about models whereby, for example, polluters, greenhouse gas emitters, would maybe subsidize the premium, so that you look at these type of models. Or, you know, the third model is always easy. In theory, you let the government pay for loss and damage or restoration. But, you know, in theory, that's always easy to say. But if you go to countries like Haiti, for example, they have limited budgets. And so it's not always realistic to simply count on government. And of course, having government pay for something which is in fact also a man-made disaster is something counterintuitive. You basically want to have financing by those who really created the loss. I'm going to my almost last point. I think there I have mentioned the SM. What is the SM? Smart mixes. I think, you know, when you listen to me now, and you've seen that I've been talking about regulation, administrative law, market-based instruments, criminal law, restoration, you know, we should realize that with our climate law enforcement, we want to achieve different goals. We talk about prevention, we talk about compensation, mitigation, adaptation, loss and damage, corrective, distributive justice. That means that is something you should realize. We're not going for one single instrument, but we need a combination of different enforcement mechanisms. Logically, market-based instruments, primarily, command and control, plus administrative and criminal enforcement, and you understand, if it were up to me, also with an autonomous criminal law, and definitely also a role for private enforcement via liability rules in climate change liability. I always say climate change liability has a limited but important role. We are not going to base climate policy only on private enforcement via climate change liability. Let that be clear. But it has a very important role in order to keep the governments awake and industry as well. So it can provide an important signal to governments to go further and to go beyond what's already happening. There is, ladies and gentlemen, one instrument that we environmental lawyers often forget because we know nothing about it. And recently, I'm going to read a bit that literature, and I found, hey, in fact, that's extremely important for us. What is that literature? Corporate governance. I know most of us environmental lawyers are not corporate lawyers, but I have, the past couple of months, been doing some research on greenwashing. And I found out there is an enormous literature in finance, corporate governance, and green finance, where people have examined what is the relationship between corporate governance, so the structure of a corporation, and greenwashing. And they came to a couple of remarkable conclusions. One of them, if you have independent directors in the board, you have less greenwashing. Another one, if you have institutional investors, so you have, for example, pension funds that are shareholders, less greenwashing. Now, these are very important results, because what does it mean? It means, you know, we are always externally of the corporation. and we come with external instruments, liability, administrative, criminal law. But what should we do? We have to look in the black box of the corporation. And we have to think, how comes there are some corporations that do bad things, others do not. And increasingly in that literature, I read now came across research from German scholars that had done experiments on decision-making within corporate boards. And they wanted to make, with an experiment, see what affects whether there will be crime or not committed by corporate boards. You know what a crucial factor was to reduce criminality by corporate boards? Adding one woman on the board. One woman on the board, and the criminality went down enormously. It had to do, I think, with all kind of very primitive features, whereby all the men in the board compete around the woman and try to impress her. Quite interesting. One woman on the board reduces cheating enormously. The second woman makes no difference anymore. One is enough. Nice research, Andri? So there I thought, this is really fascinating type of research. And you know, from there I was thinking, this is something that we as environmental lawyers should look much more into. I came through it accidentally because I worked on greenwashing, but then I realized that in a way, if you want better compliance, you should also focus on corporate governance and on corporate structures. And via that way, try to improve compliance. Dear friends, I'm talking for an hour. That means it's time for my last point, final. What I think important to me is that we have to rely on empirics. That's, you know, I just gave you a couple of results from empirical research, experiments by psychologists. We as lawyers need to look what are the results of this empirical research on what works. I think that what is also important, when we enforce climate law, we should always do it in the framework of the respect for the rule of law. What we want to avoid is symbol politics. I heard from Andri that, for example, now there are actions in some countries against individual peatland owners, starting criminal actions against them because there were some bushfires and asking expensive restoration. Yeah, those are things where I sometimes think, come on. What is, I mean, bushfires have been happening for decades. And okay, we know this is problematic and we dealt with it, but why is this now suddenly becoming, you know, having a place within the whole climate change debate, especially if you compare their contribution to the real greenhouse gas emitters that emit by the tens of thousands of tons every day. So there, I think also when we do law enforcement, some proportionality is important, and avoid symbol politics. Also avoid rules whereby you suddenly would say that there would be a priority for administrative law in environmental harm. As you understood from my theoretical expose, that is wrong. In heavy cases, priority should be with the criminal law, and we should not have strange rules that avoid application of the criminal law. Now, ladies and gentlemen, you might say, Michael, you talk the whole time about liability, administrative law, criminal law, market-based instruments. All these are relatively tough instruments. Why don't you talk about more responsive instruments, more soft instruments that could also help? Well, there are reasons why I don't talk so much about that, because for me, all of those soft instruments are maybe having an additional supplementary function, but can never be primary instruments of climate law enforcement, because all of those have important limitations. You know, we have nowadays these wonderful talks about offsetting, voluntary carbon markets, green finance. You have the talks about ISO certification and I don't know what. You know, also due diligence, for example, private certification. All of these instruments are very nice, but overwhelming literature all shows that they do not contribute substantially to reducing greenhouse gas emissions or improving environmental performance. You know, one of the reasons, for example, private certification is wonderful. MSC, FSC control, for example, a fishery at the moment that you apply for certification. But if you comply, you get your certification for the next years to come. What you then do in reality is not controlled, is not monitored. So that is problematic. Same story with, for example, this ISO certification. You know, then companies are extremely proud and say, we have an AMAS environmental management certificate, ISO, I don't know what, 9001, perfect. And so, you know, if you talk in Europe to prosecutors, they start laughing. They say, you know what? All these guys that have ISO certification, they sit with us in the criminal court. Why? Because they violate systematically. So they say, sorry, we have come across too often to companies where we see huge violations that all come with wonderful certificates. Sorry, doesn't say us anything at all. And in sum, I think that all of these additional instruments are nice, but not as primary instruments. Ladies and gentlemen, I was a month ago in an advisory board of a master's on climate law at the Free University Amsterdam. There was a guy whom I appreciate a lot called Jasper Teulings. Who is Jasper Teulings? He was the director of Greenpeace, the Netherlands, and he now works as strategic advisor for the Climate Litigation Network. And Jasper, after we discussed also voluntary initiatives and so, Jasper said the following. He said, listen, Michael, I only believe in two instruments, regulation and litigation. Regulation and litigation. And all the rest is blah, blah, blah bullshit. And ladies and gentlemen, I agree with that guy. Thank you very much.
All right. Thank you very much, Professor. Allow me to introduce myself. Good morning, ladies and gentlemen. My name is Marsa Alber, acting today as the moderator for our discussion today. So it is an honor to welcome you all to the public lecture of Designing Law Enforcement within a Climate Justice Framework. Today, as Professor have already explained, we were discussing about the climate justice framework, whether we need it or not. And he stated clearly that we do. This is the basis in order to allow enforcement of law. And we have to extend our definition of justice and environmental justice. Therefore, in the upcoming future, whenever we're going to talk about that, we have to consider their theories and practicalities, and also see whether they are applicable in the future. Today, right now, I would like to allow all the participants, whether you attend our meeting in the venue or through the Zoom meeting, if any of you have any questions, please, you may raise your hand. All right, we have one person who wants to ask.
Thank you very much for the very enlightening lecture. My name is Lulu, And I'd like to ask a question particularly about the carbon pricing, the ETS that you've mentioned earlier. I think it's very important because currently Indonesia is also designing the carbon pricing instrument regulations. And it's very important because there is probably certain like details that I'd like to know about your thoughts on that. So on the ETS, particularly for the electricity subsector, on the design of these regulations, once these ETS are imposed to the power plant, there are situations where this power plant has to design the cost of complying to the ETS system, which may include changing their technology to low carbon ones. However, it also entails the idea of passing through the cost to the consumer, which means that consumer had to pay more than before. And my question is that, does the regulation also have to anticipate such kind of situation? Thank you, Prof. Faure.
Thank you very much, Lulu, for this excellent question. And in a way, you understand the economics of carbon pricing very well. You know, in a normal market, what you would expect is indeed carbon pricing leads to the fact that you as a producer, as an operator, you would need to do more investments in order to be able to meet the standards. And so that's absolutely correct. But the idea is, of course, if you are in a competitive market, then you would try still to keep your prices low, and so to do it in a smart way, that you have smart type of investments, but you still have relatively low prices to be attractive for your consumers vis-à-vis other competitors. Now, what is the problem in the market that you talk about? You talk about the energy market. And that the energy market is, of course, heavily regulated. And of course, there is also not, I don't know, situation here, but in most energy markets, there is not an enormous amount of competition. And that is why what we often see is that there is government intervention to regulate prices, which could try to limit the type of effects that you're talking about. On the other hand, generally, what is of course an important element, that you could also say, you know, the mere fact that a relatively polluting product like energy, suppose that it is based, for example, on coal, that the mere fact that because they use, for example, coal for their energy, that as a result of that they have to pay a high carbon price, that is subsequently passed on in the price to the consumer, that also has the advantage that it signals to the consumer, aha, you are now confronted with higher prices, meaning that this is a relatively high polluting substance that you are using. And you know, the incentive effect that you expect from carbon pricing is that obviously consumers would then lower their demand for this relatively polluting product, meaning energy that is produced as a result of, for example, coal or carbon. If it would be, let's say, a coal-fired power plant that has produced the energy. And you know, here again, you get interesting questions on what climate justice exactly means. In the sense, if you look from a corrective justice perspective, you could say, okay, consumers are going to pay a higher price. That's not so bad, because it means that then automatically they also have an incentive to reduce the demand, as I told you, for this relatively polluting carbon product. And then the choice for the company is that they probably will have either to continue and lose consumers, or they will have to invest in greener energy forms. That is one of the possibilities. So that's what you ultimately need to think about, that is a desirable effect from a corrective justice perspective. Of course, what may be the problem? The problem may be that particular vulnerable groups are all confronted with higher energy prices. And suppose that especially for the poor, for example, in this country, energy would be a relatively large part of their budget. Then you get a problem of distributive justice, of how do you deal with the fact that vulnerable groups may then not be allowed to purchase energy anymore, which is also problematic. And you see, as a policymaker, where I totally agree with you, is that you have to foresee these type of effects. So you have to think, okay, what are the corrective justice, let's say, incentivizing effects, but what may also be negative effects for particular vulnerable groups. And then, what you may want to do is maybe think about a subsidization geared towards particular groups. You know, interestingly, we had the same discussion in Europe when our good friend Donald Trump and his other friends in Iran closed the Strait of Hormuz. And as a result, I don't know how it is in this country, but in the whole of Europe, energy prices at the pump increased enormously. And there, of course, we had the same debate. What do you do? Some people said, generally, the government should intervene and should, for everyone, start subsidizing energy. So we should reduce all the excises and the taxes on carbon that we currently have on petroleum products and so. But then the trouble is that may be very nice for, let's say, low-income groups, but there are also high-income groups that then suddenly start benefiting from this, whereas they maybe don't need it anymore. And so what we now tend to say in Europe is when you do these type of measures, try to do it in a targeted way, so differentiate. That you look at which are vulnerable low-income groups that suffer a lot from these type of measures, and don't do away with the measures as such, because they are good, but try to milder the consequences for some of the vulnerable groups. But again, I totally agree with you that if you introduce as a policymaker these type of measures, you need to think about, I mean, you can call it efficiency and distribution questions, you can also call it corrective and distributive justice questions. Good question, Lulu.
All right, thank you very much, Professor. Thank you, Kalulo. Do you have any further question, or can we give the opportunity to other person to ask? Thank you. Again, we are opening the opportunity for the participants here to ask directly to Professor here. Yes.
Good morning, Professor. My name is Joko Susilo from the University of Indonesia doctoral program. I would like to ask questions about, just now you mentioned about the environmental values before you explaining about the relevant substantive legal requirements as you emphasize the human rights. I want to ask, what were the environmental values you were referring to? And the second question is, do you think the ecocide can be considered as a crimes against humanity, considering the impact to the indigenous or native people these days? Thank you.
Again, excellent question. Thank you very much, my colleague Joko from UI. Joko from UI. Ah, I thought you said Universitas Indonesia, no?
Yes, that's my university, but my full name is Joko Susilo.
Okay, good. Can I call you Joko? Thank you. You know, the values and human rights issues that I was referring to was especially in the context of criminal law. So that I say there, you know what the whole problem is, Joko, that we are confronted with now? Very often we see failures of the administrative law system, in the sense people have a permit, maybe complying with the particular permit, but then you see that even though they comply with the permit, there is large environmental harm happening. I can name you one case after the other, and I'm pretty sure I think last night at the dinner with ISIL, I heard also examples of people that were with a permit creating all kind of horrible mines in a nature reserve, which on paper was lawful because they were having the permit, yet there is enormous damage. And this is an example, of course, where you also say that here particular values, and more particularly ecological values, are violated. And in that sense, I consider this whole debate on ecocide very much linked to the question, do you only have liability if you violate the conditions of a permit? Or do you basically say to an operator, look, complying with the permit is a minimum what we ask from you. But in fact, you have another obligation, indeed, to protect human rights. You know, nowadays we say that the duty to protect human rights is not only in the vertical relationship important. That means that it is an obligation for states. We now say that there is a horizontal obligation. In other words, that also companies, but individuals, may also be held to comply with human rights and take preventive measures to avoid violations. And that, of course, then it becomes interesting that you say, aha, as a corporation, you cannot simply say, I have my permit, I comply with the permit, and for the next 30 years, I do nothing at all. No. The fact that you need to comply with human rights and respect environmental values means that you also need to further invest in research and technology to see what further measures you can take to prevent, for example, dangerous climate change from occurring. You know, what environmental and climate policy is all about, Joko, is about innovation. We need to make our legal system such that we provide incentives for innovation. And you know, this is the big problem with a traditional permitting system. If you're a bit impolite, you say, the permitting system provides incentives for the operator to fall asleep. The only thing you have to do is comply with the permit, and then you can fall asleep for the next 20 years. That is, of course, fundamentally wrong, because the climate harm is only occurring, and precisely for the protection of these values, yes, we need to go beyond the permit. We need to think about how can we incentivize these operators to keep innovating, to keep thinking, to keep investing in research, to further abate pollution from occurring. And especially in the climate change area, this is why, you know what I liked so much, we had a corporate social sustainability due diligence directive in Europe, where in an Article 22, we had something magical that was an obligation for operators in scope of the directive to make a climate transition plan. And what was the idea? The company had to write down in a plan in detail how they would, I think by 2030 or so, how they would reach climate neutrality. Now that is, see again, and that has then nothing to do with permits. You can follow regulation whatever you want. You need to show as a corporation how you will attain carbon neutrality, climate neutrality. Now, this was unfortunately, as a result of very strong lobbying from industry, in a change of the directive was kicked out. But this whole idea is quite important because it signifies that we want accountability of operators for respecting environmental values beyond the mere compliance with a permit. That is a crucial thought that you must understand. And of course, you know, Joko, this whole story about ecocide, where does it come from? There was a lady who years ago started Polly Higgins, a whole organization, Stop Ecocide. And you know, the whole idea of ecocide comes in fact from the Iraq war. Why? The Iraqis, when they withdrew from Kuwait, used the environment as a weapon. There is huge evidence that they on purpose and intentionally caused enormous environmental harm just to do bad and to do harm to the Kuwaitis. For example, they started burning all kind of oil fields. There were massive, deliberate oil spills. They literally opened the oil and threw it into the sea directly. And so there was enormous environmental harm that was literally caused in the last days of the war. And this is where you use the environment as a weapon. And it is from there that Polly Higgins, who wrote the book Eradicating Ecocide, created this idea. And what she said is, look, exactly what you say. We need a new crime against humanity. And we had the classic ones, the genocides and so on, the war crimes. But we need a new one, ecocide, to be included in the Rome Statute for the International Criminal Court. That is how all of that started. And so their idea is indeed, you can not only talk about crimes against humanity, there is also crimes against nature, and that is ecocide. And you know, there was a serious panel of international experts. There was an international expert panel. There was inter alia Philip Sands, which is, according to me, one of the very best environmental lawyers in the world. He was in that panel with other very smart people. And they together in this panel made a definition of how should you formulate ecocide. And so that has been quite influential. Of course, they started a lobby, that's how it originally started, to change the Rome Convention and to include ecocide in the Rome Statute for the International Criminal Court. But what is the problem? In order to do that, I think you need a 2/3 majority. And it's pretty clear that the 2/3 majority they will never ever get. But what was then the issue? The European Commission was revising the Environmental Crime Directive. And then, of course, the Greens, more particularly Green Member of Parliament, Madame Toussaint from France, she knew this whole ecocide movement, stop ecocide movement, and she said, aha, if we cannot realize this at the international level, let's try to get this at the European level. And they did. You know, this Environmental Crime Directive is, according to me, a model. I think it's one of the very best pieces of legislation that I have seen in my career. I'll be honest. I think it's really great. And you know, one of the reasons is, I think that industry had no idea what's going on. Because to my surprise, I'm often surprised, how was it possible? This was accepted in the council, you know? I would expect, come on, an ecocide provision. I would have expected enormous lobbying by industry against this. But, you know, that's the advantage of criminal law. It's complicated. They don't understand what's going on. And so that's probably why it passed. But you see, yes, the original idea was still to include it in the war crimes provisions. But of course, you know what you also need to realize? The disadvantage of having it in the war crime provisions is then that it fits into the war crime story, and that automatically people would think, aha, ecocide, we can only apply it in times of war. Whereas, you know, there is also ecocides that can occur outside of any time of war. And so the advantage is the way it is now formulated in the Environmental Crime Directive as a qualified offense. This has nothing to do with war. This applies generally if the conditions are there. I still have to say it's, you know, maybe not perfect because it is a qualified offense. What does it mean? First, one of the other 20 offenses, but those are pretty broad, need to be applicable. And then when that causes ecocide, then the ecocide provision is applicable. Qualified offense basically means that when it is an ecocide, a much higher penalty would apply. That's basically the story. Yeah. But it is, you can definitely say, for the Stop Ecocide movement, this is a very important step and a very important gain that they won, so to say. And by the way, if you're interested in this whole ecocide implementation, what we did, there was a little group in the Netherlands headed by, we have a funny party in Parliament called the Party for the Animals. It sounds funny, but these are good people. They're serious environmental protectors. and there was one member of parliament, and he took the initiative to start a working group. I was one of the members on how to implement the ecocide provision in national law. So what we did, we made a memo, I think like 30 pages, and the idea is that this should help the implementation in the national 26 European member states, where we basically say this is the way in which you can implement this. You can look on internet and you'll see a memo on the implementation of ecocide in the member states. I think it's pretty good. Whether it will happen, I mean, they have to formally because they have to transpose the directive, but how and with which type of sanctions and so. Normally it should be done this month, but wait and see. I hope that this answers the question.
Thank you very much, Professor. Now we can continue to opening the floor for the participants if any of you would like to use this opportunity to ask our speaker today. There are a quite new concept, Professor, about ecocide. In Indonesia, this is, again, very new, considering we don't have a bill regarding climate justice or climate change yet. So, considering this, hopefully the participants may participate actively for our discussion today. If any of the participants would also like to consult or have a certain discussion with the professor, please feel free to raise your hand and use the opportunity. All right, we have one person.
Thank you very much, Professor Michel. My name is Mimin. I would like to ask first is about the recent ICG, especially opinion about climate change, which is also adopted by the UN General Assembly. So just few days ago. So I would like to ask your opinion about this advisory opinion, which is not legally binding, but whether it can be triggering more legal binding or maybe changing the regulation framework within international, also in national level, based on the ICG advisory opinion. And the second one is about the genus ecocide. I think I'm also interested to explore more about the ecocide because I think in Indonesia itself, it's already discussed more than 15 to 20 years actually, the ecocide. This is not something new in Indonesia, but the problem is the legal framework is not available yet, and also maybe in terms of international also not yet any available foundation as a reference ecocide. So I know that there are some civil system movement that in the international level they are trying to advocacy how to legalize the ecocide within the international crime framework. So maybe I just want to ask your opinion again about ecocide in more practical way. For example, in the war or in genocide in Gaza, and also maybe in Iran, and also many places in the world, like also in Myanmar, that there are convincing that there are genocide and also maybe crime against humanity are already committed by the specific countries. So, in my opinion, that actually the ecocide is already occur in that particular situation, not because of the ecocide, but it is because of the impact of the war, because the war, like in Gaza, there are so many institutions that already calculated that the genocide in Gaza, for example, has cost billions carbon due to the bomb, to the many things that already because. So I would like to how to make a legal analysis to make connection between war crime and also crime against humanity and genocide with ecocide itself in the maybe in the context of genocide in Gaza and also in another place. Thank you.
Thank you very much, sir, for a collection of excellent questions and interventions. First of all, as far as the ICJ advisory opinion is concerned, you know, we have someone in the room who is an expert on the advisory opinion. I will maybe later give him the mic. He might be willing to say a few words. Matthew Simbalon is writing a PhD thesis on the consequences of the opinion, especially for the trade environment trade-off. You know, he knows much more about it than I do, but the way that I have read the opinion, I agree with you, it's advisory, and everyone says the whole time it's advisory, therefore it's not binding, we all know. On the other hand, I've also already seen publications saying that this, of course, has enormous consequences for the obligations of the states, in the sense that states cannot deny climate change anymore, can also not say that they don't do anything about it, because there the ICJ is relatively clear, that they say if you would not take it seriously, you do not do anything at all, that it can lead to responsibility under international law. That's one of the things that they have clearly stated. If you look in the last pages of the advisory opinion, there I thought that they were relatively clear. So in that sense, I think as far as the obligations of the states are concerned, this should be a wake-up call, especially for those that have not taken any measures yet, or should. And of course we have countries, yeah, especially the oil states, Saudi Arabia and so, where still, let's say, a lot of work is to be done. Of course, what people are also examining is what are consequences for climate change litigation. There is on the one hand cases against states, and there it's of course relatively clear that with the advisory opinion in hand, states that have not done enough to avoid, let's say, responsibility under international law, they might, with the advisory opinion in hand, be confronted with more climate change litigation. But then, what is also interesting is that they say all kinds of things about reparation and loss and damage and so that there is also an obligation to repair for the consequences. And one of the things that is now also debated, of course, you know, the big hit today in climate change litigation is not anymore the cases against the states, like the urgendas, but nowadays, what is in the mode, so to say, is corporate climate change litigation, the Shell type of cases, case against Holcim, case against Total, those are now the cases. And there, of course, yeah, on the one hand, you can say, yeah, but this is international law. International law is not binding for corporations. On the other hand, there are also things said by the ICJ in the advisory opinion that definitely could affect corporate actors as well, and also may have an influence on corporate climate change litigation as well. But on this point later, I give the mic to Matthew, as I may, to add a couple of things maybe on consequences of the advisory opinion. I want to first answer the second question that you had related to the ecocide provision. You know, I find it fascinating that you say that it has been discussed in Indonesia also for 20 years, and you made the link with war crimes and even with suspects and suspicions of a genocide and so. Let me say that the way in which the whole Stop Ecocide movement worked was especially on purpose to keep it loose from the war crimes and from the war movement. You know why? Because the likelihood that you would have a criminal case for war crimes involving, and to make it very concrete, there is in the Rome Statute at this moment no ecocide provision. So there, to have responsibility of actors for ecocide under the Rome Statute, that is very, very unlikely. And so what happened, and that is also, let's say, the innovation of this provision in the Environmental Crime Directive, is that this is applicable also outside of any context of a war. Now, as far as Indonesia is concerned, read the provision here. They say the destruction of or widespread and substantial damage, which is either irreversible or long-lasting to an ecosystem of considerable size or environmental value, habitat or protected site. I'm not a specialist in Indonesia, but I talk to people, and people sometimes tell me there are horrible things going on with, for example, gold mining in Papua, where there are streams, mud streams, tails going into the ocean, completely destroying entire coral reefs and so. I think with such a provision, if Indonesia would have this provision, it's not very difficult to apply that or to cases of mining, where you see that half islands, half mountains are completely eaten. There is definitely widespread, substantial damage. It's irreversible, long-lasting, considerable size. So I think many of the things that NGOs like ICEL are complaining about that are happening here in this country could, according to me, relatively easily fulfill the ecocide provision. So I'm happy to hear that Indonesia is already for 20 years talking about this. And I would guess that if you would have this, you would have the possibility to act against some of the gross violations of environmental values that we see in this country at the moment. And so I repeat, sir, the strength of this provision is exactly that you can apply it outside of the context of war. That is the big advantage. Another issue is whether you should also act against these type of war crimes and ecocide in war, but there I tell you, it's a lot more complicated because there is no legal basis for that yet. I hope that answers a bit the question. I give the mic to Matthew to say smarter things than I can on the advisory opinion.
Thank you, Professor, for passing me the mic for a while. Allow me to introduce myself. My name is Matthew. I'm a PhD student supervised by Professor Andri and Professor Faure, but on a daily basis, I'm actually somehow an ecocide actor because my practice area is international trade law, and as you know that international trade law sometimes is against the environmental law. So, and right now in this opportunity, I would like to provide few things about the advisory opinion of the ICJ, but when it comes to the effect on state, there are two things I would like to highlight. First is the obligation on the mitigation under climate change treaties. In this case, I have no intention to discredit the adaptation obligation, but since the court have a specific attention on the mitigation, especially where it highlights Article 6 of the Paris Agreement and also some of UNFCCC obligation, it can be seen that court encourages state to reduce the adverse effect of climate change by reducing the, of course, the anthropogenic greenhouse gas emission. And this can be done by complying with the obligation under the climate change treaty, especially the UNFCCC and the Paris Agreement. And then second, when it comes to customary international law, there are a lot of set of obligations which the court, let's say, upholds. And one of them is taken from the ICJ Gabčíkovo Nagimaros case over the dam in Poland back then. And the court emphasized how the obligation to prevent the transboundary adverse effect on the environment is indeed an erga omnes obligation. So, in the sense of erga omnes, where states have the, let's say, the obligations as a whole to reduce the adverse effect, which evac not only within its territory but also outside its territory. I'm not going to talk about the controversial nature where this can conflict with the international trade law, but what I can emphasize is, although the advisory opinion is indeed advisory, it's unlike ICJ contentious jurisdiction where it has the extra authority of Security Council to enforce the award, but still, I found out actually from an article that I would like to quote. The title is "He Who Laughs Last Laughs the Most." I can share it later, maybe to Ms. Lasma or to anyone around here. But what I would like to emphasize in this article is the ICJ advisory opinion on climate change indeed has like a big moral obligation for the legislator, executive, and judiciaries of the member state of the UN. So that's like a few things from the article I would like to highlight in closing my explanation, in the sense that although it's advisory, it remains significant for the collective action of states, including international organizations, to reduce the adverse effect of climate change. Thank you. Thank you, Professor, for allowing me this opportunity.
Thanks for your excellent additions, Matthew. Back to the chair.
Thank you very much. Professor, we have a few questions in the online platform. The first question coming from Maswindu, who said, Indonesia's commercial law reform agenda is increasingly shaped by climate transition pressures, sustainable finance, carbon markets, ESG disclosure, investor expectations, and OECD accession. Commercial law is therefore becoming a key arena for climate governance. How do you see the intersection between commercial law and climate change? Is there any example of climate-compatible commercial law reform from other countries? That is the first question. We will proceed with that question first.
Let's take them one by one. Yes, clearly we see, this is an excellent question. So the question is basically, okay, is climate change also increasingly included in, let's put it broadly, commercial corporate law? And you know where it is, of course, most clearly visible is in the obligation of corporate reporting. That there you see, there is, for example, also a reporting directive that was created together with this sustainability due diligence directive. And so there, yes, we see that increasingly also on corporations, obligations are imposed as far as reporting is concerned. Why is that? It is indeed linked to the whole story that you mentioned on green finance. The whole green finance movement is, of course, becoming very important, and also commercially this has become now $1 billion business. Why? Because we see that increasingly institutional investors, and there I'm talking about pension funds and other, let's say, not commercial, but more institutional, sometimes semi-state investors, find it important that they can invest in a green way. And then, of course, one of the crucial questions for them is, how can we trust the investments that we do, that they are indeed green? And that, of course, has led to those sustainability reporting obligations. Also, what I mentioned, what is quite important, is, of course, to what extent do we completely integrate climate change into corporate decision-making? That is why, you know, the green world was extremely happy with this Article 22 in the former CSDDD, Corporate Sustainability Due Diligence Directive, which incorporated an obligation for companies to have so-called climate transition plans. I talked a little bit about it during my talk, but then I told you that as a result of effective lobbying by industry, this whole obligation on creating climate transition plans has been kicked out. So yes, you know, on the one hand, I can say that you see in many countries, especially Europe, but also the US, an increasing relationship becoming interwoven between climate change policy and commercial law. That is definitely the case. At the same time, I should also say that if you look at the empirics, be careful to become overly enthusiastic. That's what I want to say. Why? You know, there has been a research by a professor from Harvard, very smart chap called Lucien Bebchuk, and his co-author. What did they do? They looked empirically at, they did an empirical study at all the companies that were listed on the Wall Street Journal Sustainability Index. They looked at the top companies, and then they found, you know, they made all kind of claims on how great and sustainable they were, and that in fact what they started doing is to check at the real emissions of these companies. And they found out that most of these companies had more emissions than their competitors in the same sector that did not have all of this sustainability, blah, blah, blah. You know, and when I read this type of empirical research, I'm again thinking of the comments that I cited at the end of my talk from our friend from Greenpeace, Jasper Teulings, that sometimes this whole tendency of incorporating climate change in commercial law and in commercial law reform is good, yet we need to be extremely careful that that does not become an alternative for regulation, market-based instruments, and litigation. Precisely because the danger of greenwashing there is so big that all the empirical evidence, I mean, I still have to see the first paper that tells me that this has led to real reductions of emissions. All the papers I so far read, they tell exactly the opposite. So that's why, on the one hand, yes, we see this tendency. On the other hand, I'm not overly optimistic as far as the effectiveness of all of that is concerned. I hope that that answers your question online. Thanks for the question.
Thank you very much, Professor. Due to the limited time that we have, I would like to ask for one last time if anyone have any more questions, or we can end the session. All right, considering we're almost done. Oh, okay. This will be the last question we will be able to answer, considering our time is quite restricted.
Okay, check. Thanks for the opportunity. My name is Raisa. I'm not exactly from a law background, so excuse me if the question seems sort of out of the framework, but I'm wondering if can law instruments realistically operate within like the logic of hard ecological limits, like the planetary boundaries? And if what do you think about that? And if we were to try that approach, what issues do you think we could run into? Thank you.
Let me tell you yes and no. In the sense, much of the language about planetary boundaries and so is a little bit the same of the type of language about climate justice. You know, I take this very seriously, yet what I often say, I find this whole debate on planetary boundaries and so, often, let's say, I consider it as the concrete on which we have to build the house. It are the foundations. You know what the drama is a little bit? If you take these planetary boundaries seriously, you notice, I think, what was it? 7 of the 10 planetary boundaries have been trespassed already. And then, of course, the question is, what does that mean for the law? That is a difficulty, that probably the stringency of the law should be 10 times much more than what we have today. And then, of course, you run into questions of acceptability. You run into questions of legitimacy, lobbying, whether the democracy will ever accept that. But in principle, yes, the planetary boundaries are the foundations on which the legal framework is built. What is happening? Oh, okay. Someone is listening in our story. But it's time to finish instead? No. The planetary boundaries made me of my apropos. No, look, I find it very important to talk in terms of planetary boundaries, yet when you talk about the legal consequences, of course you need to translate, and then you still get into the debate, okay, we are already transpassing most of our planetary boundaries, and then we need to make decisions on what are we concretely going to do now, as far as the law is concerned, which standards are we implementing, which caps are we imposing, for example, on greenhouse gas emissions and so. And then it's a matter of making choices. Because, the tragedy is a bit, if you take the planetary boundaries seriously, then you basically say, there's too many people on Earth. Let's half of them pay harikiri, that would be an enormous solution. I don't think that that's very realistic, you see. There is a little bit the difficulty that planetary boundaries is a very good debate to help us realize that there is a lot more that has to be done with the law. And you can translate it. I heard from Mas Ahmed Santosa, who told me that they are now working on a translation of the planetary boundaries, also for Indonesia, what it would concretely mean that has to be done. Yet, then you need to take the next step, and then, of course, you have the whole debate with lobbying and intervention of all kinds of groups on, okay, what are we going to do? Which measures, legal measures, are we going to take to try to achieve, to reach these planetary boundaries? Because the consequence is obvious. The consequence is that the standards and that we have, for example, as far as caps on emissions and so are concerned, have to be increased to an enormous extent. But that also has consequences, for example, for economic growth and for development. And so that is then the debate that you need to get into, whether you are willing to accept those consequences. And so, to answer your question, yes, the law and legal instruments can help as, let's say, the legal framework building upon the foundations of the planetary boundaries, yes. But then the whole framing it in terms of planetary boundaries does not necessarily help us in defining what type of legal rules we will then have to implement. I think that would be my answer.
Thank you very much, Professor. As stated earlier, the question concluded our question and answer session for today's public lecture. Again, we would like to thank Professor Dr. Michael Faure for his kindness to be able to be here and share with us, give us more insights regarding the topic. Again, thank you very much. I give this time back to the Master of Ceremony. Thank you.
Thank you very much. Can we please give another round of applause for the amazing Professor Michael Faure? So, Bapak dan Ibu yang saya hormati, distinguished guests, we have reached the end of this morning's program, and today's lecture reminds us that designing law enforcement within a climate justice framework is not merely a technical issue. It requires us to decide what we value, what we protect, and what accountability truly means. So for Indonesia, as we deliberate on the climate justice bill, the insights shared this morning offer a rich and timely foundation. So we hope that all of us can leave this room with new ideas and with a sharpened sense of what is possible to do. So on behalf of the Indonesian Center for Environmental Law and our distinguished guest, Professor Dr. Michael Faure, terima kasih atas kehadiran dan keterlibatan dan waktu teman-teman sekalian hari ini. And please enjoy the refreshments that we have been prepared. And as the event is now formally closed, I would like to give an announcement that you guys can bisa sholat dan makan di lantai ini. And we are going to take a picture first with Professor. So can the committee help me to set up the... okay, so we are going to take the picture. Fotonya ngarahnya kemana? Oke, teman-teman boleh berbaris di bawah untuk Oke, teman-teman boleh mulai merapat. Oh. Foto di bawah aja. Oke, jadi kita teman-teman, jadi fotonya berdiri, jadi kita difoto dari sana, kitanya yang ngadep sana gitu ya. Oke, boleh teman-teman merapat. Oke, teman. Okay, we are going to take a picture.
I know.
Yes,
Have you
like,
decided how?
yeah, so like you're going to stand here, and we're going to stand up behind you. Oke, teman-teman boleh berdiri dan merapat.
Where should I go?
Here.
Okay. Where do I look?
There. That way. Oke, teman-teman boleh merapat ya ke tengah. Jelas. Oke. Nih.
Bagusnya gimana ya? Gimana ya jadinya biar kelihatan? Oh, jangan terlalu rapat. Oh, kita biar menyebar. Jadi gimana ini? Enggak di depan aja sih.
Baik, terima kasih teman-teman semua. Untuk sholatnya ada di lantai ini, musola, dan makannya juga di lantai ini. Terima kasih.